just discussed a little bit about the connection between merging this concept of slave patrols in the South and the night watch in the North and industrialization, and basically control over the people who are involved in being exploited in the means of production. Between 1881 and 1900, there were 22,793 strikes. And during that time period, the primary tools used to put down these strikes were private security agencies like the Pinkerton agencies. And so this led to massacres of people paid for by corporations through private security, and also funded efforts between coordination between private security and the military in putting down union strikes in mining communities. There was the Homestead Riot in August of 1892, and after that, it was involved 300 Pinkerton guards in Pennsylvania massacring strikers at Carnegie Steel. And then you had the development of what was known as Pinkerton Law during that time period, which would ban the use of private or federal monies to fund these private agencies. That didn't really last very long. It was a quick response to a national outcry of the massacre, but it was immediately developed through loopholes where, again, private money or federal money was being used to support private policing agencies. But to go back before that, it's important really to acknowledge the change in policing practices that occurred after the Civil War. And after the Civil War, you have the Reconstruction era, where you have federal military in the South enacting the 13th, 14th, and 15th Amendments. And you see a very brief time period where, because of the federal presence, a response to the implementation of white supremacy through law in the South, and you see for the first time African Americans holding office, taking control over local governance, and it was really a threat to the continuation of white supremacy in the South. Then you see that a turning point during this time period is the election of 1876, where Tilden received the most popular vote and did not have enough electoral votes to take office. And Rutherford B. Hayes took office through a backdoor agreement with the Electoral College that in exchange for being elected president, that he would order the withdrawal of federal forces from the South, effectively ending Reconstruction and moving forward with the development of segregation. And so out of that era came a law known as the Posse Comitatus Act. And it was a reflection, it was discussed and debated as a reflection of previous, as is with pretty much any kind of Confederate ideology, was supported through romanticization of the founding fathers in the Revolution. And so the Posse Comitatus Act was argued as going back to this revolutionary concern of a standing army and the use of standing armies against domestic populations. And what it in reality was a legal justification for removing federal forces from the South to allow white landowners to continue a de facto form of slavery and segregation in the South. And so, but the Posse Comitatus Act...
This was a federal, congressional act?
Yeah.
What year? About 1870?
It was right around 1876 with the election of Rutherford B. Hayes. And so that's how he carried out his promise to withdraw the troops from Reconstruction. It was the 45th Congress. I don't have to do it now, unfortunately. But it was largely ignored. And then it was ignored in the context of using federal troops to put down labor unrest. So in 1894, President Cleveland sent federal troops to suppress striking railroad workers. McKinley did it with the Coeur d'Alene, Idaho mining strike. So it was discussed as a method for preventing the use of standing army against it. It was largely ignored, and it was really just a response to end Reconstruction. Where it comes into play in modern discourse is through the occupation of Wounded Knee in 1973 by the American Indian Movement, where a coalition of activists took over some land that was being controlled by the federal government, and during the criminal defense proceedings for those trials, the Posse Comitatus Act was invoked for pretty much the first time in legal history as a defense to the excessive use of force in the AIM prosecutions. And so, and that kind of like rejuvenated this discussion of the use of federal force for domestic enforcement.
Also, I think just something I kind of failed to mention during the switchover from a slavery economy to the post-plantation worker economy, you had the police figuring out what to do with the slaves. And if you've ever seen really any old movie, that's where massive amounts of convict labor, free convict labor came, which the laws were just adapted to take the underclass that was created under slavery and pushing it right into free labor again. And that's what the police institution did during that switchover.
And it's important to note that the 13th Amendment has an exception for prisoners. And so we ended slavery and created a new class of people without rights, and those were prisoners, and with the goal of basically taking the people who were subject to slavery, putting them into a new institution called prison, and using them for slave labor. And we see that carrying on today, all throughout the country. Also within the context of the history of policing is you have to acknowledge the use of the military and expanding the frontier and ensuring that the era of forcing Native Americans off their lands into reservations and keeping them there. Native Americans were not given citizenship until 1924. And between that time period, you have a history of removal from 1830 on with the Indian Removal Act and using the military to force people off their lands and into reservations further and further west with less and less resources, and then keeping them there. And so the history of policing agencies, institutions, as it relates to the colonization of the West is directly related to the use of the military against Native populations, and a shift from a history of governance. And between 1787 and 1828, there's a myth, I would argue, but it's still an acknowledgement that the relationship between the federal government and various tribes was on a co-equal status as treaties were developed, and these were organized under auspices of international law. Well, after that, from 1828 through 1881, you have the development of congressional plenary power and the domination of the federal government over the control of Native American populations. And so when you look at the history of federal Indian law, it relates to the history of policing in the sense that the federal government maintained a monopoly over police powers as related to the subjugation of Native Americans and forcing people onto reservation lands and controlling those lands. There are a couple sides of history to that, but the benign federal government historical view is that this was necessary to prevent states from committing more severe atrocities. And there probably is some truth to that, but at the same time, it at first promoted the development of what was euphemistically referred to as domestic dependent nations in the Marshall Trilogy, where these tribes were recognized as sovereign entities organized under the broader sovereign umbrella of the United States. And then after that period, whenever tribes were starting to really exercise control over their individual governance, there was a case called Crow Dog. In that case, a Native American killed another Native American in Lakota territory, and the tribe handled the issue in-house, and they didn't hang the person who was guilty of the murder. And there was an outcry from the people, from white people, in a sense that how could this happen? This person should be hung. That's our law of our land. Well, the United States Supreme Court ruled that the tribes have the power to inherently control their own internal affairs, but if Congress wants to pass a law giving federal power over policing Native Americans in their communities, it can do that. And it led to Kagama and another case that resulted in federal plenary power and the development of federal policing on Native lands, which created a long legacy of neglect and forced assimilation. And so through that policy, it connects with forcing students into boarding schools and forced assimilation programs where there was a forced effort of assimilation and stripping of culture and language and identity with the idea that this would be good for tribes in the long run by forcing them to assimilate within the dominant white culture. This is important in the current context because Native American people are also the most likely ethnic population to be murdered by the police, despite being a low representation of the population overall. So, as we discussed, pretty much every aspect of the expansion and colonization of the United States, it really relates back to the use of the law to promote the goals of white supremacy, which co-align with the goals of the capitalist elites.